You are on HOA craze. The tow hook was inches away. Karen shoved a policy memo at me and screamed that the memo overwrote the bylaws. Do not point at me like that. I grabbed the edge of the paper before she could yank it back. The memo was dated 3 weeks ago, printed on HOA letterhead, signed by her, and it said my vehicle was non-compliant under emergency enforcement procedures. I said emergency enforcement for what? She jabbed her finger at my driveway and said repeat violations, which meant I had already been warned, which was the first I had heard of any of this. I work as a telecom project coordinator in Boise, Idaho. I live in a spreadsheet and a log. If I had been warned, I would have a record. She said the warning was verbal and that I chose to ignore it. I said I never spoke to her about my car. She smiled and said that was my problem, not hers. I live in Maplewood Commons HOA, a community where leadership treats neighbors like suspects during disputes. Pamela Smith is the welcome committee chair. She wears a gray windbreaker and a black sun hat like it is part of a uniform, and she carries a portable folder organizer into every confrontation. That folder was on her hip now, held by a strap, bulging with printed pages. She pulled another sheet and held it up. She said, "This is your second notice, and if you do not comply by tomorrow morning, the tow company is authorized to remove the vehicle." I said, "Second notice? I never got a first notice." She said that was because I refused delivery. I said I have been home every day this week. No one knocked. She tapped the paper and said the records show attempted delivery on the 10th, the 14th, and the 17th. I said, "Show me the delivery log." She said she did not have to show me anything, and that the burden was on me to stay informed. The stakes were immediate. I share the car with my sister, who works early mornings across town. A tow would strand both of us. Pamela said the tow was scheduled for 7 a.m. the next day, unless I submitted proof of compliance and paid a $100 expedited review fee by end of business today. I asked what compliance even meant. She said my vehicle registration had to match the approved resident list and that my car was registered under a different address. I said I updated everything when I moved in 2 years ago. She said the system showed otherwise and that I needed to resubmit with a notarized affidavit. I said that was never a requirement. She smiled again and said the requirements changed and that the board sent an email blast in June. I checked my phone, no email. She said I probably filtered it to spam, which was not her problem. I asked to see the original complaint. She said complaints were confidential. I said, I have a right to know who reported me. She said no, I did not, and that she had a committee for that. I said then I need to speak to the board president. She said the president delegated enforcement to her, and that she was the final authority until the hearing. I said hearing? You just told me I had until tomorrow morning. She said the hearing was in 2 weeks, but the tow would proceed unless I complied today. I said that makes no sense. She said it made perfect sense if I had been paying attention, and that she would make an example out of me so everyone learns. A neighbor across the street opened his blinds and stood in the window, watching. Pamela glanced over, waved, and turned back to me. She said if I had a problem with the process, I could file a formal appeal, but the appeal deadline was yesterday. I said yesterday, how could I appeal something I just found out about today? She said ignorance of the deadline was not an excuse, and that the bylaws were available online. I said I read the bylaws when I moved in, and none of this was in there. She pulled a laminated sheet from her folder and held it under my nose. She said this is the updated compliance policy, effective immediately, and that emergency enforcement supersedes the standard process when a resident demonstrates a pattern of non-compliance. I said pattern. This is the first time anyone has said anything to me about my car. She said that was incorrect, and that the file showed a prior incident in 2022 involving the same vehicle. I said I moved here in 2023. I did not live here in 2022. She said the record was clear, and that I needed to take it up with the hearing officer if I wanted to dispute it. I kept my phone in my pocket because I was saving one clip for the finale. I said fine, I will bring every piece of paper I have. She said paper was not sufficient, and that I needed certified copies with raised seals. I said certified copies of what? She said vehicle registration, proof of address, lease or deed, and a signed compliance attestation form, which was available at the management office between 9 and 3 on weekdays. I said today was Friday, and I had a call scheduled until 5. She said that was my scheduling problem, not hers. I said this whole thing sounded like a setup. She leaned in close and said if I implied bad faith one more time, she would add obstruction to the file, which carried an additional $200 fine and a mandatory board review for expulsion. I said expulsion. You cannot kick someone out of their home over a car registration mix-up. She said the bylaws allowed removal for repeated violations and that the board took compliance seriously. The neighbor across the street stepped outside now, holding a phone. Pamela turned and waved again, brighter this time, like she was posing for a camera. She said I had until 4 p.m. today to submit the paperwork, and that failure to comply would result in immediate enforcement. I said immediate enforcement. You just said the tow was at 7 a.m. tomorrow. She said plans change, and that the tow company was on standby. I said on standby for what? You just made up this whole thing an hour ago. She said she had been documenting my non-compliance for weeks, and that the file was extensive. I said show me the file. She said the file was confidential until the hearing. I said you cannot tow my car based on a secret file. She said I could try explaining that to the tow driver, and that she had already provided him with authorization paperwork. I called my attorney as soon as Pamela left. He said the timeline was absurd, and that no legitimate HOA enforced towing with same-day paperwork demands. He said he needed one more document today to file an injunction, but the HOA was stalling to run out the clock. I said what document? He said a copy of the complaint that triggered the enforcement action, which the HOA was required to provide within 24 hours of a written request. I said I never made a written request. He said make one now, and send it certified mail with a read receipt. I said certified mail takes days. He said send it email too, and CC the management company. I hung up and opened my laptop. I drafted the request, attached a copy of Pamela's memo, and sent it to the HOA board address and the management company address listed on the website. The auto-reply said the management company was closed for the weekend and would respond on Monday. I called the attorney back. He said file the request with the county clerk as a formal records demand under state statute, which had a 72-hour compliance window. I said 72 hours is still past tomorrow morning. He said it creates a paper trail and that we could cite the delay as evidence of bad faith if they towed anyway. I drove to the county clerk. The office closed at 4:30. I arrived at 4:15. The clerk asked what I needed. I said I needed to file a records request with the HOA under Idaho Code 30-30-109. She said HOAs were private entities, and the county did not have jurisdiction unless the request involved deed restrictions or lien filings. I said the HOA filed a violation against me, and I needed the complaint records. She said that sounded like a civil dispute, and I should contact a lawyer, and I said I already did, and he told me to file here. She said he was wrong, and that I needed to file directly with the HOA. I said the HOA refused to provide the records. She said then I needed to file a motion with the district court, which required a filing fee and a case number. I said how long does that take? She said weeks, maybe months. I thanked her and left. I called the management company on my way back. The voicemail said the office was closed and would reopen Monday at 9 a.m. I called Pamela, no answer. I called the HOA board president, no answer. I called the non-emergency police line and asked if they could do anything about a tow threat based on undisclosed records. The dispatcher said it sounded like a civil matter and that police could not intervene unless the tow was illegal or involved stolen property. I said it felt illegal. She said feelings were not evidence, and that I should document everything and contact a lawyer. I said I already did. She said then I was doing everything I could, and she wished me luck. I went home and checked the neighborhood group chat. Someone had posted a message 2 hours ago. The message said I was a repeat offender, and that the HOA was finally taking action. The post included a photo of my car in the driveway, license plate visible, with a caption that said this resident has ignored multiple warnings and continues to violate parking rules. I scrolled through the replies. Most were supportive of the post. One neighbor said good, people like that ruin property values. Another said the HOA should tow immediately and send a message. A third said I probably moved here to dodge enforcement at my old place. I recognized none of the names. I checked the post history of the original poster. The account was 2 days old. The only other post was a welcome message from Pamela, thanking the new member for joining. I screenshotted everything and emailed it to the attorney. He replied within 10 minutes. He said the post was defamatory if the prior violations were false and that we could use it as evidence of a coordinated harassment campaign. I asked if that stopped the tow. He said no, but it strengthened the case for damages if the HOA proceeded. I said damages did not help me tomorrow morning. He said file a police report for harassment and keep a camera ready when the tow truck arrived. I said a police report for what? Someone posted my car online. He said frame it as targeted harassment with financial consequences and make sure the responding officer documents the timeline. I called the non-emergency line again. The dispatcher said she would send someone when available. I said when. She said within 2 hours. I said the tow was at 7 a.m. She said file the report tonight, and if the tow driver arrived in the morning, call 911 and report it as theft in progress. At 6 p.m., someone knocked on my door. I opened it expecting the police. It was a vendor, holding a clipboard. He said he was here to verify compliance with HOA vehicle regulations. I said, who sent you? He said the HOA management company. I said the management company is closed. He said they contracted him for after-hours inspections. I asked to see his credentials. He handed me a business card. The card had a generic company name and a phone number. No logo, no address. I said this does not prove anything. He said he had a work order signed by Pamela Smith and that he needed to photograph my vehicle registration and insurance documents. I said no. He said refusal to cooperate would be noted in the report. I said note whatever you want. I am not showing you anything. He said suit yourself, and he stepped off the porch and took photos of my car with his phone. I said you cannot do that without my permission. He said the HOA authorized the inspection and that the vehicle was in plain view on HOA property. I said this is my driveway. He said the driveway is part of the common area under the CC&Rs, and that all common areas are subject to inspection. I closed the door and called the attorney. The attorney said the vendor inspection was a provocation tactic, and that Pamela was trying to manufacture a confrontation. He said do not engage, do not give them anything, and document every interaction. I said they are taking photos of my car right now. He said let them, and take your own photos of the vendor. I hung up and opened my camera app. I stepped outside. The vendor was crouched by my rear bumper, photographing the license plate. I said I am recording you. He said that was fine, he was recording me too. I said on whose authority? He said the HOA. I said show me the work order. He stood up and held the clipboard at an angle so I could not read it. He said confidential. I said you just told me Pamela signed it. He said I could take it up with her. I said give me your name and company. He said it was on the card. I said the card has a phone number, not a name. He said call the number if I had a problem. I took a photo of him, the clipboard, and his vehicle. He got in his truck and drove away. I called the number on the card. Voicemail. No company name, just a generic greeting. I left a message asking for a callback and the name of the person who hired them. No response. I emailed the attorney with the photos. He said the vendor was likely a subcontractor hired off the books, and that Pamela was building a paper trail of non-compliance to justify the tow. I said paper trail. He did not even give me a receipt. He said that was the point. The inspection was informal enough to avoid accountability, but official enough to claim I was uncooperative. At 8 p.m., a deputy arrived for the harassment report. I explained the situation. The deputy asked if anyone had threatened me. I said Pamela threatened to tow my car tomorrow morning. He said that was a civil matter. I said she sent a vendor to provoke me. He said did the vendor threaten you? I said no, but he took photos without my consent. The deputy said the vehicle was in plain view and that photography in public was legal. I said this is my property. He said the property line was unclear without a survey and that the driveway might be part of the HOA common area. I said according to who? He said according to the CC&Rs, which he had not read. He said if I felt harassed, I could file a restraining order, but I would need evidence of repeated unwanted contact. I said Pamela has contacted me 4 times today. He said 4 times in one day was not necessarily harassment, especially if the contact involved HOA business. I asked if he could at least document the timeline. He said he would write a report, but it would not stop the tow. I thanked him and he left. At 9 p.m. my sister came home. She asked why I looked stressed. I explained the situation. She said that sounded insane, and asked if I had proof. I said I had the memo, the vendor photos, the group chat screenshot, and the email trail. She said good, and asked what I was going to do. I said I was going to stay up all night and figure out how a 2022 violation attached to my name when I did not live here in 2022. She said that sounded like fraud. I said it did, and that was why I was not sleeping. I opened my laptop and searched the HOA website for violation records. The site had a portal for residents to view their account. I logged in. My account showed 1 open violation dated today, and 1 closed violation dated October 2022. I clicked the 2022 entry. The details were sparse. The violation type was listed as vehicle non-compliance. The complainant was listed as anonymous. The resolution was listed as warning issued. No supporting documents. No photos. No correspondence. I checked the metadata on the entry. The creation date was 2 weeks ago. I screenshotted the metadata and emailed it to the attorney with the subject line "smoking gun." He replied within minutes. He said the backdated entry was evidence of falsification and that we could use it to argue the entire enforcement action was fabricated. I said, use it where? He said at the hearing, or in a lawsuit, if the HOA proceeded with the tow. I said the hearing was 2 weeks away, and the tow was in 6 hours. He said file an emergency motion in the morning, and I would meet him at the courthouse at 8 a.m. I said 8 was after the tow. He said call the tow company directly and tell them the authorization was under dispute. I said I do not have the tow company number. He said Pamela would have given it to the vendor. Check the vendor phone number. I called the number again, still voicemail. I left another message saying the tow authorization was fraudulent and that legal action was pending. At 11 p.m., I drove to the management office. The office was dark. I parked and took photos of the exterior, the closed sign, and the hours posted on the door. I emailed the photos to the attorney with a note that said management company was unavailable for the entire enforcement timeline, and he said perfect, that proves the HOA acted without oversight. At midnight, I started digging into the 2022 violation. I pulled up the neighborhood group chat archive and searched for posts from October 2022. I found 3 posts from that month. One was about a potluck, one was about a street repaving schedule, one was about a vehicle towed from the guest lot. The tow post was from a resident named Greg, who said his friend's car was towed during a visit, and that the HOA refused to explain why. Several neighbors replied with sympathy. One neighbor said the HOA had been cracking down on unapproved vehicles. Another said the rules kept changing. A third said Pamela was handling enforcement now, and that she was aggressive. I clicked on Greg's profile. His last post was from early 2023. I sent him a direct message asking if he still lived in the neighborhood, and if he remembered the 2022 tow incident. No response. At 1 a.m., I searched the county property records for the address listed on the 2022 violation. The address matched my current address. The ownership records showed the property was owned by a couple named Thompson from 2019 to 2023. I searched for Thompson in the neighborhood group chat. No results. I searched public records for Thompson. I found a forwarding address in Oregon. I drafted an email explaining the situation and asking if they had ever received a vehicle violation notice in October 2022. I sent it and waited. At 2 a.m., I got a reply. Thompson said they never received any violation notices during their time at the property and that they sold the house specifically to get away from the HOA. Thompson said Pamela had harassed them over landscaping violations that were never in the bylaws and that the board refused to intervene. Thompson said they kept every piece of correspondence from the HOA and that they would be happy to share it if it helped my case. I asked if they could send it tonight. Thompson said they would scan the file and email it within an hour. At 3 a.m., the file arrived. It was 60 pages. Most of it was landscaping complaints. None of it mentioned vehicles. I searched the file for the word vehicle. No results. I searched for October 2022. One result, a letter from the management company dated October 15th, acknowledging receipt of Thompson's complaint about Pamela's conduct. The letter said the board was reviewing the matter and would respond within 30 days. I searched for a follow-up. Nothing. I emailed the attorney with the file and a note that said the 2022 violation never existed. At 4 a.m., I printed the Thompson file, the metadata screenshot, the group chat screenshots, and the vendor photos. I put everything in a binder. I labeled the binder evidence and put it in my car. I set an alarm for 6:30 and tried to sleep. The alarm went off. I got up, made coffee, and waited. At 6:55, a tow truck turned onto my street. I grabbed my phone and the binder and stepped outside. The truck stopped in front of my house. The driver got out. He was wearing a reflective vest and holding a clipboard. I said, "Good morning, can I help you?" He said he was here to tow the vehicle at this address. I said, "On whose authority?" He said, "The HOA." I said, "The HOA authorization is fraudulent." He said he had a signed work order. I said, "Show me." He held up the clipboard. The work order was signed by Pamela Smith. I took a photo. I said this vehicle is registered to me, and I have not been notified of any valid violation. He said take it up with the HOA. I said I am taking it up with you, and I am telling you the tow is not authorized. He said he had a contract with the HOA, and that he was following the work order. I said, if you hook that vehicle, I am calling the police and reporting it as theft. He said that was my right, and he was doing his job. He walked to the back of my car and started positioning the truck. I called 911. The operator asked for my emergency. I said someone is attempting to tow my vehicle without my consent. She asked if the vehicle was stolen. I said no, it is my car, but the tow is based on a fraudulent HOA violation. She said that sounded like a civil matter. I said the tow driver is hooking my car right now. She said she would send a deputy, but it might take a few minutes. I said I need someone now. She said do not interfere with the tow driver and wait for the deputy. I stood on the sidewalk and recorded. The tow driver ignored me. He connected the hook and started raising the front end of my car. A neighbor across the street opened her door and watched. Another neighbor walked out to his driveway. I said this is an illegal tow based on a fabricated violation. The driver said I was welcome to file a complaint with his company. I said, what company? He pointed to the logo on the truck. I took another photo. I said I am filing a theft report. He said, good luck with that. At 7:15, a deputy arrived. I explained the situation. The deputy asked the driver for the work order. The driver handed it over. The deputy looked at it and handed it back. He said the work order appeared valid. I said the authorization is fraudulent. I have evidence. I held up the binder. The deputy said evidence of what? I said the HOA fabricated a violation from 2022 and backdated the entry to justify this tow. The deputy said that sounded like something for a judge. I said the car is about to be towed right now. The deputy said if the HOA authorized the tow, it was a civil dispute, and he could not intervene. I said so he can just take my car. The deputy said if I believed the tow was improper, I could file a claim and recover the vehicle later. I said later, I need it today. The deputy said I should have resolved this with the HOA before it got to this point. I said I tried. They refused to give me the records. The deputy said he was sorry, but his hands were tied. He walked back to his patrol car and left. The tow driver finished securing my car. He handed me a receipt. The receipt had a phone number and an address for the tow yard. He said the car would be held until I paid the tow fee and provided proof of compliance. I said how much? He said $250 for the tow, plus $50 per day storage. I said storage for what you just took it. He said storage starts today. I asked when I could pick it up. He said as soon as the HOA released the hold. I said the HOA has no right to hold my car. He said take it up with them. He got in the truck and drove away. I stood in the driveway holding the receipt. My sister came outside. She said what just happened. I said they towed the car. She said on what grounds? I said grounds Pamela made up. She asked what we were supposed to do now. I said I was going to the tow yard, and then I was going to find every piece of paper the HOA did not want me to see. I called a ride and went to the tow yard. The yard was surrounded by a chain-link fence with barbed wire on top. The office was a small trailer near the gate. I walked in. A woman behind the counter asked how she could help me. I said my car was just towed, and I needed to pay the fee and take it back. She asked for the receipt. I handed it over. She looked it up in the system. She said the vehicle was under an HOA hold, and I could not retrieve it until the hold was released. I said, how do I get the hold released? She said, contact the HOA. I said the HOA is the one who put the hold on. She said then, I needed to resolve it with them. I asked if I could at least get my registration and insurance documents from the glove box. She said no, the vehicle could not be accessed while under hold. I said, that makes no sense. I need those documents to resolve the hold. She said HOA policy. I asked to speak to a manager. She said the manager was not in. I asked when the manager would be in. She said Monday. I said today is Saturday. I cannot wait until Monday. She said there was nothing she could do. I thanked her and left. I went to the HOA management office, still closed. I called the emergency contact number listed on the website. Voicemail. I left a message saying my car had been towed, that the authorization was fraudulent, and that I needed the hold released immediately. No callback. I went home and called the attorney. He said the tow was actionable, and that we needed to file an emergency motion Monday morning. I said Monday is 2 days away. He said the courthouse was closed on weekends. I said what am I supposed to do until then? He said document everything and prepare for the hearing. I said the hearing is 2 weeks away. I need my car now. He said I could try filing a small claims action for the tow fees, but that would take weeks too. I said this is insane. He agreed. I spent the rest of Saturday reviewing the Thompson file. I found a pattern. Every complaint Pamela filed against the Thompsons involved vague rule violations that were not in the bylaws. Every response from the management company said the board was reviewing the matter. No follow-up, no resolution. The last letter in the file was from Thompson's attorney, threatening a lawsuit if the harassment continued. 2 weeks later, the Thompsons sold the house. I searched public records for other former residents. I found 3 families who sold between 2021 and 2023. I cross-referenced their addresses with the HOA violation portal. All 3 had backdated violations. 2 were vehicle-related. 1 was a landscaping violation. The creation dates were all recent. I emailed the attorney with a summary. He said it looked like a pattern of selective enforcement tied to property turnover. I said tied to what? He said possibly inflated fees or kickbacks from vendors. I said prove it. He said we would need financial records. On Sunday, I filed a public records request with the county for HOA financial disclosures. The clerk said the HOA was required to file annual reports with the state and that I could request copies from the Idaho Secretary of State. I went home and filed an online request. The system said the records would be available in 3 to 5 business days. I said 3 to 5 days, I need them now. The system said expedited processing was available for an additional fee. I paid the fee. The system said the records would be available in 1 business day. On Monday morning, I met the attorney at the courthouse. We filed an emergency motion to release the vehicle and enjoined further enforcement actions pending a hearing. The clerk said the motion would be reviewed by a judge within 24 hours. I said 24 hours, my car has been in the tow yard for 2 days already. The clerk said that was the fastest timeline available. The attorney said we would also file a motion for sanctions if the HOA did not produce the complaint records. The clerk said that was a separate filing. We filed it. At noon, the HOA financial records arrived by email. I downloaded the file and opened it. The report covered 3 years. I searched for vendor payments. I found a line item for towing services, $12,000 in 2023, $18,000 in 2024. I searched for vehicle violations in the minutes. I found references to 6 enforcement actions in 2023, 15 in 2024. I cross-referenced the enforcement dates with the financial records. Every tow generated a $250 payment to the tow company and a $50 administrative fee to the HOA. I calculated the total. 21 tows times $300 equaled $6,300 in revenue. I emailed the attorney. He said the fee structure was a red flag and that we needed to find out who approved the vendor contract. I searched the minutes for vendor approvals. I found one entry from January 2023, a motion to approve a new towing vendor, proposed by Pamela Smith, seconded by the treasurer, passed by unanimous vote, no discussion, no competitive bids, no disclosure of the fee structure. I searched public records for the tow company. The company was registered as an LLC in Idaho. The registered agent was listed as Michael Torres. I searched for Michael Torres. I found a property record showing Torres owned a home in Maplewood Commons. I checked the neighborhood group chat. Torres was a member. His profile said he was on the Architectural Review Committee. I emailed the attorney. He said that was a conflict of interest and possibly fraud. At 3 p.m., the judge granted the motion to release the vehicle. The order required the HOA to lift the hold within 2 hours. I called the tow yard. The woman at the counter said the hold was still active. I said the judge ordered it released. She said she needed written confirmation from the HOA. I said the HOA is not going to confirm anything. She said then she could not release the vehicle. I called the attorney. He said fax the court order to the tow yard. I said fax? Who uses fax? He said tow yards. I found a fax service online and sent the order. The woman called back 10 minutes later and said the vehicle was ready for pickup. I paid the tow fee with a credit card over the phone and took a ride to the yard. The car was parked near the gate, covered in dust. I inspected it for damage. The front bumper had a small crack. I took photos. I got in and drove home. My sister was waiting. She said thank God. I thought we were going to be stuck without a car all week. I said we still might be, if I do not win this hearing. I spent Monday night preparing for the hearing. I organized the binder into sections: timeline, evidence of falsification, financial records, conflict of interest, and witness statements. I printed extra copies. I wrote an opening statement. I practiced delivering it. My sister listened and said it sounded good but too long. I cut it in half. On Tuesday, I received a notice from the HOA. The notice said my account was past due and that I owed $350 in fines and administrative fees. I called the attorney. He said do not pay it, it was part of the harassment pattern. I said what if they put a lien on my house? He said they could try, but we would challenge it. I said challenge it how? He said at the hearing, with all the evidence we just compiled. On Wednesday, someone knocked on my door. I opened it. It was a contractor, holding a clipboard. He said he was here to inspect the property for code violations. I said on whose authority. He said the city. I asked to see his credentials. He handed me a badge. The badge looked official. I called the city code enforcement office. The person who answered said they had no inspections scheduled for my address. I said someone is at my door right now claiming to be a city inspector. The person said ask for his employee ID number. I asked the contractor. He said he did not have it with him. I told the city. The city said that was a red flag, and I should ask him to leave. I told the contractor to leave. He said I was refusing a lawful inspection. I said you are not a city inspector. He said prove it. I held up my phone and said I just called the city. They have no record of you. He walked back to his truck and drove away. I took a photo of the license plate and emailed it to the attorney. He said Pamela was escalating again, and that we needed to document every incident. On Thursday, I received an email from the HOA board president. The email said the board was scheduling an executive session to discuss my violations and that I was not invited. I forwarded it to the attorney. He said executive sessions were supposed to be limited to specific topics like contracts and personnel, and that enforcement actions had to be discussed in open meetings. I said, so what do I do? He said file a complaint with the management company and show up to the next board meeting. I said, when is the next meeting? He said, check the website. I checked. The next meeting was scheduled for 2 weeks from now, the same day as my hearing. On Friday, I went to the management office. The office was open. I walked in and asked to speak to the property manager. The receptionist said the manager was in a meeting. I said I would wait. She said it might be a while. I said I have time. I sat down. 30 minutes later, a man in a suit came out and introduced himself as the property manager. I explained the situation. He said he was aware of the dispute and that the board was handling it. I said the board authorized a fraudulent tow based on a fabricated violation. He said that was a serious allegation. I said I have proof. I handed him the binder. He flipped through it and said he would review it and get back to me. I said when? He said within a week. I said a week is not fast enough. I have a hearing in 10 days. He said he could not expedite the review process. I asked why not. He said the board had final authority over enforcement actions, and his role was administrative. I said, so you are just going to let them do whatever they want. He said he was required to follow the bylaws. I said the bylaws do not allow backdated violations. He said that would be addressed at the hearing. I left. If this story has you hooked, hit subscribe. There is so much more coming, and you do not want to miss what happens at the hearing. On Saturday, a contractor I hired to replace my front steps refused to start work. He said the HOA sent him an email saying the project was not approved and that he could be fined if he proceeded. I called the contractor back and asked to see the email. He forwarded it. The email was from Pamela, and it said all exterior work required architectural review approval, and that my application was denied due to incomplete documentation. I said I never submitted an application because the bylaws do not require approval for replacing steps. He said he was not getting in the middle of it and he would come back when I had written approval. I called the attorney. He said Pamela was interfering with my property rights and that we could add it to the complaint. I said the complaint is already 10 pages long. He said make it 15. On Sunday, I got a message from a neighbor named Rita. Rita said she saw my posts in the group chat and that she had been through something similar with Pamela 2 years ago. I asked what happened. Rita said Pamela filed a noise complaint against her after Rita voted against Pamela in a board election. The complaint said Rita was hosting loud parties, which was false. Rita said she was home alone most nights. The HOA fined her $500 and threatened to put a lien on her house. Rita hired an attorney and fought it. The HOA eventually dropped the fine, but Rita said the stress was not worth it. I asked if she had any records. Rita said she kept everything. I asked if she would testify at my hearing. Rita said she was terrified of retaliation and that she could not be seen helping me. I said I understand, but your testimony could make the difference. Rita said she would think about it. On Monday morning, I received an email from the board president. The email said the executive session had concluded and that the board voted to uphold the enforcement action. The email said I could appeal the decision at the hearing, but the appeal was limited to procedural issues, and the board's findings of fact were final. I forwarded it to the attorney. He said that was not how appeals worked, and that we would challenge the findings at the hearing. On Tuesday, I received a certified letter from the HOA. The letter said my appeal hearing was rescheduled to the following Monday, 1 week earlier than originally planned. The letter said failure to appear would result in automatic dismissal of my appeal and immediate resumption of enforcement actions. I called the attorney. He said the reschedule was improper and that we could object on due process grounds. I said objecting does not help if they dismiss the appeal. He said show up and argue the reschedule was designed to prejudice my case. I said fine, but I am running out of time to get Rita to testify. I called Rita. She did not answer. I texted her. No response. I drove to her house. She opened the door and said, "Please leave, I cannot help you." I said I just need 5 minutes. She said, "Pamela is watching. If she sees you here I am next." I said, "Watching how?" Rita pointed to a house across the street. Pamela's car was parked in the driveway. I said she lives here. Rita said she moved in last year, right after the noise complaint. I said that is harassment. Rita said it is a free country, she can live wherever she wants. I said will you at least write a statement? Rita said no, I am sorry, I cannot. She closed the door. On Wednesday, I received another email from the tow company. The email said I owed an additional $50 in storage fees for the 2 days my car was in the yard. I called the attorney. He said do not pay it. The fees were part of the damages we were claiming. I said, what if they send it to collections? He said, let them. It strengthens the case. On Thursday, I prepared my opening statement for the hearing. I rehearsed it twice. My sister said it was good but too angry. I said I am angry. She said I know, but you need to sound calm and factual. I revised it again. On Friday, I received a call from an unknown number. I answered. The voice said this is Michael Torres. I own the tow company. I said I know who you are. He said I heard you are making some serious accusations. I said I am stating facts. He said facts according to who? I said according to the financial records and the conflict of interest disclosure, you never filed. He said I did not have to file anything. I am a vendor. I said you are a vendor and a board member. He said architectural review is not the board. I said it is an HOA committee, and you have a financial interest in enforcement actions. He said prove it. I said I will, at the hearing. He hung up. On Saturday, I finalized the binder. I printed copies for the board, the property manager, and the attorney. I labeled each section with tabs. I added a cover page with my name, the date, and the case summary. I packed everything in a backpack along with my laptop, a charger, and a portable recorder. On Sunday, I reviewed the bylaws one more time. I highlighted every section that contradicted Pamela's enforcement actions. I made a list of questions for the board. I practiced asking them in a calm, neutral tone. My sister listened and said I sounded like a lawyer. I said good. On Monday morning, I woke up at 5 a.m. I made coffee, showered, and put on a button-down shirt. My sister said I looked official. I said I need to. She asked if I was nervous. I said yes. She said you are going to do great. I said, I hope so. I drove to the HOA clubhouse. The parking lot was half full. I recognized several cars from the neighborhood. I parked near the entrance and grabbed the backpack. I walked in. The lobby was empty, except for a table with a sign-in sheet. I signed in. A staff member said the hearing would start in 10 minutes, and that I should wait in the hallway. I sat on a bench outside the meeting room. The door was closed. I could hear voices inside. At 9 a.m., the door opened. The property manager stepped out and said the board was ready. I walked in. The room was set up with a long table at the front and rows of chairs facing it. The board members were seated at the table: the president, the treasurer, the secretary, and Pamela. Pamela was wearing her gray windbreaker and black sun hat. She had the portable folder organizer on the table in front of her. I sat in the front row. The attorney was not there yet. I texted him. He replied saying he was stuck in traffic and would be there in 15 minutes. I said the hearing is starting now. He said stall. The president called the meeting to order. He said the purpose of the hearing was to review my appeal of the vehicle enforcement action. He said the board had reviewed the file and that I would have 10 minutes to present my case. I said 10 minutes is not enough. He said those were the rules. I said the rules allow for a full hearing. He said the board had discretion to set time limits. I said that discretion has to be reasonable. He said 10 minutes was reasonable. I asked if the board had read the evidence I submitted. He said the board reviewed a summary, prepared by the property manager. I said a summary is not the same as the full file. He said the summary was sufficient. I said I have additional evidence. He said submit it in writing after the hearing. I said the hearing is the time to present evidence. He said the board had already made its determination, and the hearing was limited to procedural objections. I said that is not what the bylaws say. He said the bylaws grant the board authority to interpret the rules. I said that authority is not unlimited. He said my time was starting now. I stood up and opened the binder. I said the enforcement action is based on a fabricated violation. I showed the metadata screenshot proving the 2022 entry was backdated. Pamela interrupted and said the metadata was unreliable. I said metadata does not lie. She said I could have altered it. I said I did not, and I have the portal login records to prove it. The president said that was outside the scope of the hearing. I said how is proving the violation is fake outside the scope? He said the hearing was about procedural compliance, not factual disputes. I said the facts determine whether the procedure was followed. He said the board found the facts sufficient. I said based on what? He said based on the complaint. I said show me the complaint. He said the complaint was confidential. I said I have a right to confront my accuser. He said HOA hearings are not criminal trials. I said they still have to be fair. The attorney walked in. He apologized for being late and asked if he could address the board. The president said the hearing was already in progress. The attorney said he had new evidence. The president said submit it in writing. The attorney said the evidence was time sensitive. The president said the board would review it after the hearing. The attorney said that defeated the purpose of a hearing. The president said the rules were clear. The attorney said the rules required the board to consider all relevant evidence. The president said the board had discretion. The attorney said discretion was not the same as arbitrary decision-making. The president said the board resented the implication. The attorney said the implication was supported by the record. Pamela stood up. She said I was wasting everyone's time, and that the board had more important business. I said more important than due process. She said due process was not unlimited, and that I had been given multiple opportunities to comply. I said comply with what? A fake violation. She said the violation was documented. I said show me the documentation. She opened her folder and pulled out a packet. She said this is the original complaint, filed in October 2022. I said I did not live here in October 2022. She said the complaint was filed against the property, not the person. I said the portal entry lists my name. She said the portal was updated when I moved in. I said updated how? She said the prior owner's name was replaced with mine. I said that makes no sense. Why would you replace the name if the violation was resolved? She said it was not resolved, it was pending. I said pending for 3 years. She said yes. I said that is absurd. She said it was the process. I asked to see the original complaint. She handed me the packet. The complaint was a single page, printed on HOA letterhead, with a handwritten note that said vehicle parked in violation of guest lot rules. The note was signed anonymous. The date was October 10, 2022. I checked the metadata on the portal entry. The creation date was 2 weeks ago. I said this does not match. She said what does not match? I said the complaint is dated 2022, but the portal entry was created this year. She said the portal entry was a data migration. I said data migration from what? She said the old system. I said what old system? She said the previous property manager used a different database. I said show me the old database. She said it was destroyed. I said destroyed when? She said when the contract ended. I said that is convenient. She said it was standard procedure. The attorney asked if the board had any records of the data migration. The president said that was an administrative question. The attorney said it was a factual question. The president said the board did not have access to the old system. The attorney said then how did the complaint get transferred? The president said the property manager handled it. The attorney asked if the property manager was present. The president said no. The attorney asked when the property manager would be available. The president said after the hearing. The attorney said we need the property manager here now. The president said that was not possible. The attorney said then the hearing should be continued until the property manager could testify. The president said the board had discretion to proceed. The attorney said proceeding without a key witness violated due process. The president said the board disagreed. I pulled out the financial records. I said the board has a financial incentive to uphold enforcement actions. I showed the line items for towing fees and administrative charges. Pamela said those were legitimate expenses. I said legitimate for who? She said for the HOA. I said the HOA collects $50 every time someone gets towed. She said that was a processing fee. I said processing what? She said paperwork. I said $50 for paperwork. She said it covered staff time. I said what staff? She said the property manager. I said the property manager who is not here. She said yes. I pulled out the vendor contract. I said the tow company is owned by a board member. Pamela said that was not true. I said the registered agent is Michael Torres. She said Torres is not on the board. I said he is on the architectural review committee. She said that is not the board. I said it is an HOA body. She said it is advisory. I said advisory with enforcement authority. She said no. I said then why does the committee approve or deny projects? She said because the board delegated that authority. I said so it is an enforcement body. She said no. I said this is circular logic. She said I was wasting time. The attorney asked if the board disclosed the conflict of interest when it approved the vendor contract. The president said there was no conflict. The attorney said Torres owns the vendor and serves on an HOA committee. The president said the committee is independent. The attorney said independent of what? The president said the board. The attorney said the board appoints the committee. The president said that does not create a conflict. The attorney said it does if the committee member profits from enforcement actions. The president said the vendor was selected through a competitive process. The attorney said show me the bids. The president said the bids were not retained. The attorney said that is a violation of state law. The president said the board followed the bylaws. The attorney said the bylaws do not override state law. The president said the board interpreted the bylaws in good faith. The attorney said good faith does not immunize fraud. Pamela stood up again. She said I will make an example out of you so everyone learns. The room went quiet. The president said that was not helpful. Pamela said it needed to be said. I said you said that to me before. She said so what? I said you are on record threatening me. She said it was not a threat, it was a policy statement. I said policy statements do not include personal pronouns. She said I was twisting her words. I said I was repeating her words. She said go ahead and call whoever you want, I have a committee for that. I smiled. I said you said that before too. She said because it is true. I said it is true that you weaponize committees to avoid accountability. She said I was being ridiculous. I said I was being accurate. I pulled out my phone. I said I kept my phone in my pocket because I was saving one clip for the finale. I played the recording. It was from the driveway confrontation. Pamela's voice came through clearly. Go ahead and call whoever you want, I have a committee for that. I will make an example out of you so everyone learns. The room erupted. Several neighbors in the back started whispering. One person laughed. The president banged his gavel and said order. Pamela said that recording was illegal. I said Idaho is a one-party consent state. She said I had no right to record her. I said I had every right. She said it was entrapment. I said entrapment is when law enforcement induces a crime. This is just documentation. The attorney said the recording was admissible. The president said the board would determine admissibility. The attorney said the board was not a court. The president said the board had authority over the hearing. The attorney said authority was not the same as immunity. I played the second clip. It was from the vendor confrontation. The vendor's voice said the inspection was authorized by the HOA and that he was following orders from Pamela Smith. I paused it and said this vendor was sent to provoke me. Pamela said that was not true. I said then, why did he show up without notice? She said it was a compliance check. I said compliance checks require notice. She said not under emergency enforcement. I said there was no emergency. She said I was non-compliant. I said based on a fake violation. She said the violation was real. I said prove it. She said the complaint was proof. I said the complaint was anonymous and backdated. She said I was repeating myself. I said because you were not answering. I played the third clip. It was from the tow yard. The tow yard clerk's voice said the vehicle was under an HOA hold and that I could not retrieve it until the hold was released. I said this hold was placed without a hearing. Pamela said the hold was temporary. I said temporary for 2 days. She said I could have resolved it faster if I had complied. I said I tried to comply. You kept moving the deadline. She said I did not move anything. I pulled out the memo. I said you gave me until 4 p.m. Then you said the tow was immediate. Then you said it was at 7 a.m. She said those were different phases of enforcement. I said phases are not in the bylaws. She said the board authorized phased enforcement. I said show me the authorization. She said it was in the executive session minutes. I said executive sessions are confidential. She said exactly. The attorney stood up. He said the board cannot rely on confidential minutes to justify enforcement actions. The president said the board had authority to conduct executive sessions. The attorney said executive sessions are for specific topics, not enforcement. The president said enforcement involved personnel matters. The attorney said personnel matters involve employees, not residents. The president said the board interpreted it broadly. The attorney said the interpretation was wrong. The president said the board disagreed. The attorney said then, we will take it to court. I pulled out the HOA financial records. I said this is the smoking gun. I showed the payments to the tow company. I said the HOA collected $6,300 in fees from 21 tows over 2 years. I showed the vendor contract. I said the contract was approved by Pamela, without competitive bids. I showed the conflict of interest. I said the vendor is owned by a board member. I showed the backdated violations. I said every tow was triggered by a fabricated complaint. I said the pattern is clear. Pamela creates fake violations, authorizes tows, and the HOA collects fees. The attorney said this is fraud, and possibly racketeering. The room erupted again. Neighbors stood up. One person shouted, "Is that why my car was towed last year?" Another shouted, "I got fined for a violation I never committed." A third shouted, "This whole board is corrupt." The president banged the gavel and said the hearing was over. I said, "You have not ruled on my appeal." He said the board would issue a written decision within 10 days. I said, 10 days? You just heard evidence of fraud. He said the board needed time to review. I said, review what? It is all here. He said the meeting was adjourned. Pamela stood up and tried to leave. A neighbor blocked the aisle and said, "You owe me $300. Pamela said, "Get out of my way." The neighbor said, "Not until you explain why my car was towed." Pamela pushed past and walked out. The neighbor followed, shouting. The attorney and I walked outside. He said that went better than expected. I said better. They did not rule. He said they did not have to. The recording was enough. I said enough for what? He said enough to file a complaint with the state attorney general and the insurance carrier. I said insurance carrier. He said HOAs carry liability insurance, and the carrier does not like fraud. I said, will they do anything? He said if the carrier threatens non-renewal, the board will cave. I said, how long does that take? He said days, maybe a week. I went home and emailed the recording, the financial records, and the binder to the state attorney general's office. I filed a complaint alleging fraud, conflict of interest, and selective enforcement. I attached a cover letter summarizing the case. I sent copies to the insurance carrier listed on the HOA website. The carrier replied within 2 hours. The email said they were opening an investigation and that the board needed to respond within 72 hours. On Tuesday, I received an email from the board president. The email said the board was suspending all enforcement actions pending the investigation. The email said the vendor contract was under review. The email said Pamela had been removed from the welcome committee. I forwarded it to the attorney. He said it was a start, but not enough. I said, what else do I need? He said an apology, a refund, and a policy change. I said I will take it. On Wednesday, I received a call from the property manager. He said the board wanted to settle. I said settle what? He said they would refund the tow fees, void the violation, and issue a formal apology. I said what about the policy change? He said the board was drafting an updated enforcement policy that bans surprise inspections without written notice. I said send it over. He said he would email it by end of day. On Thursday, the new policy arrived. It required written notice with a 10-day cure period before any enforcement action. It banned anonymous complaints. It required competitive bids for vendor contracts. It required conflict of interest disclosures. I showed it to the attorney. He said it was solid. I said, what about Pamela? He said she was out. I said, out how? He said the board called a special meeting last night and removed her from all committees. I said, what about the board itself? He said 2 members resigned. I said, which ones? He said the treasurer and the secretary. I said, good. On Friday, I received a check for $350. The check memo said refund of tow fees and administrative charges. I deposited it. I also received a letter from the board. The letter said the board regretted the enforcement action and that it was based on inaccurate information. The letter said the board was implementing reforms to prevent future incidents. The letter said the board valued my membership in the community. I showed it to my sister. She said, do you believe them? I said no, but I will take the win. On Saturday, the neighborhood group chat exploded. Someone posted a screenshot of an email from the insurance carrier. The email said the carrier was issuing a non-renewal warning and that the HOA needed to implement reforms within 30 days or lose coverage. Another neighbor posted a photo of Pamela's house with a for sale sign in the yard. A third neighbor posted a message saying good riddance. I did not comment, but I saved the screenshots. On Sunday, Rita called. She said she saw what happened at the hearing. I said you were not there. She said I watched from the parking lot. I said why did you not come in? She said I was scared, but after I saw everyone stand up, I realized I should have helped. I said you can help now. She said how? I said run for the board. She said me. I said yes. The neighborhood needs people who are not afraid of Pamela. She said Pamela is gone. I said her allies are still here. She said I will think about it. On Monday, I received an email from the Attorney General's office. The email said the investigation was ongoing and that I might be contacted for additional information. I replied with a link to the shared folder containing all the evidence. The email said thank you, and that the office would keep me updated. On Tuesday, the board held an open meeting to discuss the insurance warning. The room was packed. I sat in the back. The president read the carrier's letter aloud. The letter said the HOA had 30 days to adopt new governance policies, conduct a financial audit, and provide proof of compliance training for all board members. The president said the board was committed to meeting the requirements. A neighbor raised his hand and asked if the board would resign. The president said no. Another neighbor asked why not. The president said the board was elected by the members and it would serve out the term. A third neighbor said we should hold a recall vote. The president said the bylaws allowed recalls, but they required a petition signed by 50% of the members. The neighbor said then, let's start a petition. I left before the meeting ended. I went home and drafted a recall petition. I listed the grounds: failure to oversee enforcement, conflict of interest, and breach of fiduciary duty. I printed 50 copies and walked the neighborhood. I knocked on doors. I explained the situation. Most people signed. A few refused. One person said they did not want to get involved. Another said the board was doing their best. A third said I was causing trouble. I said trouble was already here. I was just documenting it. By the end of the week, I had signatures from 60% of the members. I submitted the petition to the property manager. He said the board would schedule a recall vote within 30 days. I said 30 days. The bylaws say 14. He said the board needed time to prepare. I said prepare for what? He said prepare a defense. I said there is no defense. The evidence is public. He said the board had a right to respond. I said fine, but the vote happens in 14 days or I file a complaint. He said he would talk to the board. On Thursday, the board scheduled the vote for 2 weeks from Friday. I received a notice in the mail. The notice said the vote would be conducted by written ballot, and that ballots had to be submitted by 5 p.m. on the day of the meeting. I showed it to the attorney. He said make sure you vote, and encourage everyone else to vote. I said I am already planning a door-to-door campaign. He said good, this is your chance to finish it. I spent the next 2 weeks knocking on doors. I handed out flyers summarizing the case. I explained the recall process. I answered questions. I listened to stories. 3 neighbors said they had been fined for violations they never committed. 2 said they were threatened with liens. 1 said her car was towed while she was on vacation, and the HOA refused to reimburse her. I took notes. I added their stories to the shared folder. On the day of the vote, I arrived at the clubhouse early. The parking lot was full. I walked in. The lobby was packed. I saw Rita. She was holding a clipboard. She said, I am running for the board. I said that is great. She said, I am nervous. I said, you will do fine. She said, what if I lose? I said, you will not lose. Everyone here wants change. The meeting started at 6 p.m. The property manager collected ballots. He said the results would be announced after the count. The count took an hour. At 7 p.m., the property manager returned. He said the recall passed with 78% of the vote. The room erupted in applause. The president stood up and said the board accepted the result, and that new elections would be held within 30 days. I raised my hand and said I nominate Rita for president. Someone seconded. Rita was elected by voice vote. Rita's first act as president was to hire a new property manager. The second act was to conduct a financial audit. The audit found $12,000 in missing funds, all linked to vendor payments approved by Pamela. The third act was to file a civil complaint against Pamela and Michael Torres. The complaint sought restitution and damages. Torres settled within a week. He agreed to refund all towing fees and dissolve the vendor contract. Pamela refused to settle. The case went to small claims court. The judge ruled in favor of the HOA and ordered Pamela to pay $15,000. She appealed. The appeal was denied. On the day the judgment was finalized, I received an email from the Attorney General's office. The email said the investigation was complete, and that the office was referring the case to the county prosecutor for potential criminal charges. I forwarded it to the attorney. He said this is as good as it gets. I said what happens now? He said now you move on. I said move on, I just spent 3 months fighting this. He said I know, but you won. I said it does not feel like winning. He said give it time. On Saturday, I drove to the shared mailbox cluster to pick up a package. Pamela was there. She was loading boxes into her car. She saw me and froze. I nodded and walked past. She said this is not over. I said it is for me. She said I will appeal again. I said good luck with that. She said you ruined my reputation. I said you ruined your reputation. She said I was just following the rules. I said no, you were making up the rules. She slammed the trunk and got in her car. She drove away. I picked up my package and went home. On Sunday, Rita called. She said the new board approved a transparency policy. The policy required all enforcement actions to be logged in a public database. The policy required all vendor contracts to be posted online. The policy required all board meetings to be recorded and archived. I said that sounds perfect. She said it was your idea. I said it was everyone's idea. She said the board wants to thank you. I said no need. She said yes need. You saved this neighborhood. I said I just wanted my car back. She laughed and said well, you got a lot more than that. On Monday, I received a letter from the insurance carrier. The letter said the HOA was in full compliance and that coverage would continue. The letter said the carrier appreciated the board's commitment to reform. I filed the letter with the rest of the evidence. My sister said, "Are you ever going to throw all that away?" I said no, I am keeping it forever. She said why? I said because the next time someone tells me HOAs are harmless, I am going to show them the receipts. On Tuesday, I updated my vehicle registration. The new address was already in the system. No affidavit required, no notary, no fee. I drove to the management office and submitted the paperwork. The new property manager said everything looked good. I said that is it. He said that is it. I said no hidden requirements. He smiled and said no hidden requirements. On Wednesday, I finished replacing my front steps. The contractor showed up without incident. No emails from Pamela. No interference. The project took 2 days. The steps looked great. My sister said they better, after all that. I said it was worth it. She said was it really? I said yes, because now I know exactly how much documentation you need to beat an HOA Karen. She said how much. I said all of it. On Thursday, the neighborhood group chat posted a goodbye message from Pamela. The message said she was moving out of state and that she hoped the community would learn from recent events. No one replied. The post was deleted an hour later. Someone asked who deleted it. Rita said I did, and I am not apologizing. On Friday, I went to the clubhouse to drop off my final set of documents. The new property manager said he would file them. I said thank you for everything. He said I should be thanking you. This place was a disaster before you showed up. I said I did not show up to fix anything. I just wanted to park my car. He said well, you fixed a lot more than that. I said I guess I did. On Saturday, I sat on my new front steps and watched the neighborhood. A family walked by with a dog. A kid rode past on a bike. A neighbor waved from across the street. It felt normal. It felt quiet. It felt like home. My sister came outside and handed me a coffee. She said, "What are you thinking about?" I said I am thinking about how much paperwork it takes to prove someone is lying. She said that is dark. I said that is reality. She said, "Do you think it is over?" I said I hope so, but I am keeping the binder just in case. She said of course you are. I said you would too if you lived through this. She said probably. On Sunday, I received an email from a neighbor I had never met. The email said thank you for standing up to the board, and that I inspired him to run for a committee seat. I replied and said good luck. The neighborhood needs more people like you. He said, people like me. I said people who do not take garbage from HOA Karens. He said I will do my best. I said that is all anyone can do. On Monday, I went back to work. My boss asked how the HOA situation turned out. I said it turned out fine. He said fine, I heard you took down the entire board. I said I did not take anyone down, I just held them accountable. He said that is the same thing. I said maybe. He said so are you done fighting? I said for now. He said for now. I said yeah, until the next Karen shows up. He laughed and said there is always a next Karen. I said I know, but at least I have a system now. He said a system. I said receipts, timelines, and a good attorney. He said that is a hell of a system. I said it worked. I hope you enjoyed this wild HOA mess.